Okay, then we are ready. So in our last class, I think we stopped at differentiating between analytical and normative jurisprudence. Two, very important classification within the subject of jurisprudence that we make. So, analytical jurisprudence, for a quick recap of the topic, analytical jurisprudence essentially is descriptive in its nature. So, what it essentially deals with is it deals with this question of what is law. That's exactly what legal theory is all about, in the sense that we discussed the other day. And that's known as general analytical jurisprudence. On the other hand, there is something called particular analytical jurisprudence that deals with certain concepts of law, certain basic concepts of law like rights, duties, property, possession, etc., that you're going to study in the next semester. So that's your analytical jurisprudence. And then on the other hand, you have something called normative jurisprudence, something that is not merely descriptive, but is also prescriptive in certain way, in the sense that it does some kind of value judgment. It looks into the moral quality of law, whether a law is good or bad. That is something that normative jurisprudence deals with. Now we will start with in the next module. We are going to take a natural law school of jurisprudence. Now, natural law school of jurisprudence would come under this heading that we just described, that is normative jurisprudence. So yes, that's the broad classification that we made. However, just remember that it does not have to be restricted only to natural law school. There could be other schools that look into the law in terms of its value. For example, sociological school also does that. That is also normative in a different sense of the term. But if you're using it in the moral sense of the term, then look at it mostly from the natural law schools approach. So that's how we make this classification between analytical and normative jurisprudence. Now, ultimately, what jurisprudence deals with is that it deals with law. Okay, law or various concepts of law. Now the question is, what kind of law are we dealing with? Okay, so the kind of law that we are dealing with, anyway, defining this is a big task. Okay, we will only be able to justify that in the course of time as we take up specific legal thinkers. But for now, just for the sake of introduction here, we are dealing with law, but not all kinds of law. Okay, we are dealing with a very particular kind of law. Okay, law that concerns us, the humans. Okay, there are certain laws, okay, which are known as scientific laws. Okay, those are also laws, and we use the term law for them, and we also use the term law for laws that affect us in a different way. Okay, I'm not saying that scientific laws are not applicable to us, but they're applicable to us in a completely different way than human-made laws are. Now we are to make that distinction. We will go into detailed discussion later, but for introduction's sake. So, for example, you have different laws, scientific laws. Okay, so for example, laws of gravity. Okay, evolution, or for that matter, Newton's laws of motion. All those are laws that apply, those are scientific laws that apply to physical bodies. Okay, and physical bodies have no choice but to behave according to those laws. So those laws are essentially not really laws, but description of a physical reality. That's how things are. Okay, those are kind of, it's not that this thing falls because it ought to fall. No, it just falls. Okay, so we observe the phenomenon and then say that there is something, okay, that is causing this fall of this object. Okay, what is causing that? Whatever it is, we call that some kind of law. Okay, so when Newton observes an apple falling from a tree, he came up with this idea of gravity. But that doesn't mean that gravity didn't exist before Newton realized that there is something called gravity. Okay, so these are the laws which exist in the nature, and those are out there, okay, and we merely find them in the nature, okay. We describe how things work, okay. So this object, or for that matter me as a human, that is also made of matter, we are all bound by such laws of nature, okay. So those are different kinds of laws, okay, in which we do not have any choice, okay, we are bound by it. On the other hand, when we talk about human laws, the kind of laws that we are concerned about here, those are different in the sense that those are also applicable to us, but we always have the choice of not following those laws, okay. We always have the choice of not following those laws. So for example, if a law says that I'm not to cross the road when the light is red, okay, I have a choice that I exercise here, okay. I either cross the road or I do not, okay. If I do not cross the road when the light is red, that means I'm following the law, and if I do, then I'm not following the law. So I have a choice, okay. So here, this law is binding on us in a different way, okay, in the sense that it gives us choice, and it says that you are to do one and not the other, okay. So you see the difference, that here you have a choice, whereas in the other kind of laws, the question of choice doesn't arise, okay. So here you have to make predictions about whether someone will or will not follow the law, okay. So that prediction is very important. I mean, you can only make predictions, that's what I'm saying. Whereas in case of other physical laws, you can, with mathematical calculation, you can with almost like to a great certain degree predict the behavior of things, but here you can't be sure, okay, you can only make guesses. So I hope you understood the difference here. So we are not concerned about laws of nature in the sense that those scientific laws, but the laws which are applicable to us, the humans, okay. So yes, apart from apart from this distinction, as I have just made, there could be other, different kinds of human laws, okay? Human laws, you may call them law, or you may call them something else, okay? So another distinction would be, for example, you are expected to behave in a certain way, certain etiquettes, okay? That you dress up properly, or that you do, and that you respect your elders, or something like that, okay? So there could be different, rules in a particular society that are, those rules are applicable to humans, okay. Now the question is whether those rules will be legally enforceable or not, okay. Not all rules will be legally enforceable, okay. Only the rules which are made by the state, okay, in its different manifestations are the laws that we are concerned about, not other things, okay. So for example, you are expected to help the poor, okay. You do not help the poor. Will that be legally enforceable? Unless a law that makes it mandatory for you to help the poor, it cannot be. But there might still be a moral rule, or there might be a religious rule which says that you ought to help the poor, or you ought to respect someone. But those need not necessarily be enforceable in the sense that it will only depend on whether there's a law that says that you do that, okay. So that's another kind of distinction that we make, okay. So for now, here in this particular portion that we are going to deal with, we are only concerned about the laws which are enforceable, okay. But then this also raises many questions, okay. So I will not be able to answer that now, okay. So the question is that what are the limits of this laws that we are talking about, okay. So we will look into the limits of these laws, that is the state-made laws, in the course of time. Can it expect us to do anything it wants, or are there certain limits on what it can expect us to do or not to do? Those questions we will look into later, but for now jurisprudence deals with these specific kinds of laws. So I hope that is clear. Is that clear? Okay then. So yes, but when I say that we are dealing with these kinds of law, I'm not saying that these laws will not have moral content. Okay, I'm not saying that these laws, state-made laws, will have no moral content. It is quite often the case that the laws made by the state, when it is necessary, will definitely have moral content, because it is difficult for the state to apply the laws which are not considered moral by the society. But I'm not saying that state laws have to always conform to the popular idea of morality. So, for example, if you did a survey in India, there is a very high likelihood that most people would not approve of homosexuality. Okay, now, as of now, you can say that homosexuality is not considered as a crime in this country. Okay, so, but then it might not reflect the popular morality of this society. So this is why I'm saying that we are concerned only about the laws which are made by the state. Okay, they may have moral content, they may not have moral content, but quite often they overlap with the moral scale of a particular society. Now, further, you can take it to another extreme and then say whether laws have to be moral all the time, or whether law and an immoral law could be considered as law. Those are certain questions that we'll be dealing with in greater detail later on. So for now, my basic explanation to you is that we are concerned about the laws which are made by the state, and jurisprudence essentially deals with those laws. Okay. So yes. So if things are clear until now, then we will look at some specific definitions of law, just for introduction's sake. Okay, just for the sake of introduction. Okay, that are very important for us at this stage. Okay, so what are those? So let's start with legal positivism, the different positivists, okay, as you find in the reading that I have sent you, okay, where the part that deals with quest for the definition of law. So how do we define what is law? Okay, defining what is law is a very difficult task. If I asked you, if you were here, physically present here, then if I asked you, as it has been the case earlier, you would say that what is law? Law is a set of rules and regulations, that are binding on us. Okay, and if we don't follow it, then there will be certain consequences, as some of you had already said earlier. Well, sorry, there's a call. Hello. Uh-huh. Mm-hmm. Mm-hmm. Sorry, everyone. I accidentally disconnected. So anyway, are you able to hear me now? Am I audible? Okay. Okay. So yes, let's look at some of the definitions. Okay, for the sake of introduction, so that you are not like completely you do not get the shock by the kind of definitions that you will be coming across later on, just for the sake of introduction. Okay, so I hope this is still being recorded. Let me see, just a second. Yeah, still being recorded. So yes. So yes, what are those definitions? So as I just told you, as quite often I have asked my students as to what their understanding of law is, they say that laws are nothing but rules, which are binding on us. Okay, and if we do not follow those rules, then there'll be consequences, as you have also said in the previous class. Okay, that's a good definition. It's a very good definition, in fact, but it's not all. Okay, there's a lot more. Okay, so the thing is, what are rules? Then I ask, what are rules? Okay, what rules are to be considered as laws, and what rules cannot be considered as law? Okay, so which are the rules that can be considered as part of what we call as law, and which are the rules that we cannot consider? Okay, is there a particular source from which the rules have to come? Okay, do those rules have to have certain moral content? Okay, is it enough for those rules to merely exist? Or should there be certain external, factors that determine the validity of those rules? Okay, so I'm getting you confused maybe at this stage. So for now, just remember that this is what we are going to deal with in the course of time. Okay, so and then further one may ask, okay, so yes, it is a law if there is a sanction. Okay, there is a consequence that follows. What if there are no sanctions? Will there still be law? Okay, what if someone successfully avoids application of sanction when he or she does not follow the rule? Is there no law then? These are the questions that one might raise. What happens in a legal system when most of the rules, most of the times, are not followed by the people? Can we say that those rules still, are laws of that legal system? So many such questions will be raised by you, okay, in the course of time. So these are the things that we will look into. Okay, but for now, let me introduce some of the definitions of law which have been given by some of the different thinkers. Not the exact definitions, we'll look at them later on. Yeah. So let's start with some of the hard positivists, or also known as descriptive positivists, okay, or fact positivists. Okay, within that criteria, we have you can start with Hobbes, okay, Thomas Hobbes, okay, although we also study him under natural law for a different reason. So you can start with Thomas Hobbes, and then Jeremy Bentham, and then John Austin. Although John Austin is credited as the father of positivism, but in reality it started with, like, as a proper subject, it started with Jeremy Bentham. Okay, now all of them have given a particular definition of law. What is that? They say that law is command of the sovereign. This you might have studied in political science already. Okay, now it's not that simple a statement. I'm going to explain this later on in much greater detail. Okay, so they say that law is the command of the sovereign. Okay, now it's a simple definition, but it creates more definitions that we need to deal with. Okay, what are those? Says that law is command. So what is a command? You have to define command. Okay, from who? Sovereign. Now we have to define what is sovereign. They also say that if you do not obey the command of the sovereign, then there will be sanctions. Okay, now we have to define what is a sanction. Okay, it also raises questions like, if someone someone is able to escape the application of the sanction, then is there any law as per the definition given by Austin or Bentham and others? Okay, so this is the first kind of definition given by law, whether you are satisfied with it or not, but this is the first kind of definition which has been given by the legal positivist. This has many criticisms we will go into. Okay, so this was criticized by certain legal realists. Okay, certain legal realists had said that there is no fact of law. There is no fact of law. You cannot describe it. You can only predict what the effects of law could be. Okay, so there are certain legal realists who question this particular approach to defining law. They say that law is not a fact. Okay, it's not out there that it's going to happen exactly the way it is out there. No, it doesn't work like that. Okay. In fact, from the very definition given by them, they, in a very justifiable way, say that one can only predict what the law is. One cannot for certain say that this is what the law is. One can only make prediction of what the law is. Why do they say so? They say that if, as the fact positivists say, okay, you can only describe what the law is, then how do we describe what the law is? Okay, so you can describe it from the perspective of a bad man, someone who's always trying to escape the grip of law. Okay, and that particular person can tell when the law will be applied to them and when he or she will be successfully able to avoid it. Okay, so it's their perspective that actually defines what the law is. Okay, so that's a different kind of positivism though. Okay, it doesn't completely digress, but it is a criticism of the idea of legal positivism. So, and then you have other legal positivists like H.L.A. Hart, okay, who are not considered as fact positivists, they are considered as normative positivists. So, H.L.A. Hart and Hans Kelsen are other positivists, okay. So, H.L.A. Hart says that, laws have certain kind of, laws are, kind of they have certain normative nature, okay, normative not in the moral sense of the term. Both H.L.A. Hart and Hans Kelsen say that they are normative in nature, okay. They are also prescriptive in a certain way, but they are not of the kind, as has been described by John Austin and other, fact positivists, okay. There is some, can you explain the term fact positivist? Okay, yes. So fact means what? Fact means something that is out there, okay? It is the truth, okay? It is the truth, okay, as one might say, okay? It is what it is, okay? Fact is, at the end of the day, I mean, I would say that, okay, there is no true fact, there is fact. Fact is always the truth, okay? So when the fact positivists essentially try to define law in a descriptive sense of the term, okay? They observe a phenomenon and then they describe it. So for example, if I am the sovereign, I command you to do something and then you do not do that, then I impose some sanction on you, okay? So this is what? This is a description of a situation, okay? From this description, I come to the definition of what is law, as John Austin does. So this is merely a description. You do not see any normative, even in the amoral sense, okay? Any normative content here that, I ought to follow the law. There is no question of ought even in the, non-moral or immoral sense here, okay? It's merely a description of a situation. So that's why we call it fact positivism. Contrary to this, thinkers like H.L.A. Hart and Hans Kelsen, they are not content with such definition. So don't get worried, okay? I will explain this in much greater detail with interesting examples later on. For now, these are merely introductory. So you have thinkers like H.L.A. Hart and Hans Kelsen who are considered as normative positivist, okay? H.L.A. Hart is also considered as soft positivist. So what they essentially say is that law is normative in nature, okay? So H.L.A. Hart says that, in ancient times there were rules, okay? But those were merely primary rules. Primary rules merely create rights and duties, okay? But mere primary rules will not suffice. They can function only in small, close-knit, communities. But as population increase, as the idea of legal system emerges, you need another kind of rules, okay? Another set of rules. Those are known as secondary rules, okay? Secondary, there are three broad kinds of secondary rules that he identifies. One is the rule of creation, and then there is the rule of amendment, and then you have rule of recognition, okay? So rule of creation, the three different rules are basically necessary, okay? So the first rule basically determines what kind, first rule basically determines what new rules are coming into existence, okay? And then the second rule, that is basically of amendment. So if you want to make changes in the existing rule, then you need rules of amendment. And then the third, secondary rule is your rule of recognition. Now this rule of recognition is a higher kind of rule, higher than all other rules, in the sense that it determines what rules form the part of the legal system. So if you have these two different kinds of rules, okay, then you have something called legal system. And all these rules are essentially laws of that particular legal system. So this is a kind of definition which was given by H.L. Hart. And when it came to obligation, he had this thing specifically to say. It's that even when people escape the application, the grip of law, okay, even when someone successfully escapes the grip of law, not in all cases, but in some cases, okay, even then there is something called law, okay. But if you take the Austinian definition, in every single case, someone who escapes the application of sanction, there is no case of law, okay. So that's a particular problem that is addressed by H.L. Hart. Then you have someone called, Hans Kelsen. He says that, laws are nothing but a, pyramid of norms. Okay, so you have one norm. Okay, a lower norm is validated by a higher norm. That norm is validated by another norm, and then ultimately you have one grand norm. Okay, that grand norm validates all other norms. So this is another way in which laws have been defined by Hans Kelsen. Then you have many other thinkers, okay? Then you have, for example, there is this famous debate between Hart and Fuller, okay? On the question of whether there is moral content in law, okay? Hart says that there is no necessary connection between law and morality. Quite often there could be moral content in law, but there is no necessary connection between law and morality. So an unjust law is a law nonetheless, okay? Is a law nonetheless. It could be bad law, it could be good law, but it is law nonetheless. Whereas Fuller says that there has to be certain moral content of law, and he gives a particular definition of what those particular, approach to identifying those, moral contents that we will look into later on. Then you have other thinkers like Ronald Dworkin who say that laws, as opposed to what H.L. Hart says, that there are different kinds of rules, okay? Dworkin says that no, apart from rules, there are also something called principles, okay? Principles work in a different way. So whereas rules, function in an all or nothing fashion, in the sense that if two rules, come in conflict, then one prevails over the other. But if two principles come in conflict, it doesn't work in an all or nothing fashion, okay? One can eclipse the other to a certain, extent. So these are the different things, that we are going to study later on. So these are the different definitions of law that we will study. Then you have Joseph Raz, who says that laws consist of authoritative positive considerations. Basically, he deals with this question of legal authority that we are going to study later on. So these are some of the positivist definitions that we will look into in this subject. So I hope you guys are following me till now. If there is any confusion, you can ask me, and if there are any deeper confusion, that is a good sign that we will deal with later on when we take up specific topics. So are you with me so far? Okay, then. Okay. So yes, so apart from this, we have, we deal with other questions as well. Okay, so some of you were asking about justice. Justice essentially, no, we do not have one way of defining justice, and there are different kinds of justice, okay? Now, but some of the other concepts that we are going to deal with are, for example, what is the right thing to do? But then, the limits of this, syllabus doesn't allow us to venture beyond certain basics that we deal with in this subject. Otherwise, there are more serious things that we have to deal with. But given that we have to complete everything in one semester, we will not be able to deal with your questions of justice in great detail. I'll only be able to introduce to you different kind of concepts of justice. Okay. But anyway, we are going to look at, natural law school. Natural law school that will say that there are certain higher laws, okay? There are certain higher laws. Those laws are higher in the sense that they are above the man-made laws, okay? So positive laws are quite often man-made laws. but there are certain higher laws, laws which are above the positive laws, and they come from certain transcendental source, okay? So those laws are universal, okay? Those laws are unchanging throughout time and space, okay? If you were living 2000 years ago, those laws would have been same then as they are today, okay? But the positive law 2000 years ago must have been different from what it is like today, okay? And you can change, amend the positive law. You cannot change or amend the laws of nature, okay? They're universal in their application. Now, there are many different justifications for that, okay? Some say that laws of nature, natural law is to be traced from the nature itself, the way things are. Others say that, natural law is inscribed in our, in our mind, in the sense that if we close our eyes, if we think in the absence of all the corrupting factors, then we will come to right conclusion about what is natural law. Then there are others who equate natural law with reason. Now, what is reason? That is another difficult task that we have to deal with. Apart from that, there are other thinkers, okay? There are certain, religious thinkers like Thomas Aquinas, St. Augustine, who say that natural law is nothing but, laws given by God, okay? So that's another approach. So if these are higher laws, these have to come from a higher superior authority. So who's the superior authority over that of a man? It's God. So it has to come from God. So something like that, something that is authoritative and binding on us have to come from some command, okay, some source, and that source cannot be human. That source have to be something higher than human, so it must be God, okay. Now, anyway, that's something possible only in Abrahamic religion because they believe in one God. But it breaks down in other, elsewhere. So yes, so this is another approach to dealing with, defining what is natural law. And then subsequently, you had many, secular thinkers, okay? Secular thinkers in the sense that these thinkers were, I'm not saying that they were not religious, they were religious otherwise, but they tried to, as the Europeans ventured elsewhere, they came across. So I have a question here. So, sir, you were saying law is based on the fact that God exists. It's not, it's not me who's saying that because I do not believe in God. I'm an atheist. So that's not my view. But then, the scholastic thinkers like St. Augustine and Thomas Aquinas, they say that, these higher laws, higher natural laws exist because there is a higher authority. So who's the higher authority according to them over that of, or most, people around you? Who has authority over us? That must be God according to them. So yes, so natural laws are nothing but commands of the God. It's something that has come from the God. So they are binding on everyone on this earth, okay? So that's what they are saying, okay? That's not my view. I should make it crystal clear because I do not believe in God, nor do I believe in existence of any such higher authority. So anyway, that's one of the approaches. So subsequently, there came other thinkers who found that not everyone believed in the kind of God which these thinkers were talking about, okay? If you now that they started traveling elsewhere, they came across people who didn't believe in one God, they believed in many gods, okay? Now, which God's command would it be? So that it just became all the more confusing. So they tried to create a very, secular, neutral idea of natural law. An idea of natural law that would exist even if there were no God or gods, whatever it is, okay? So certain higher principles that pre-exist the idea of God. Is that possible or not possible? Something that we'll discuss later on. So you have Victor Hugo Grotius, you might have heard of, okay? Father of international law. So he came up with these ideas. Then you have certain contractarians who are talking about natural rights, okay? So they are experientialist in nature. For example, John Locke, he talks about such idea of natural law. And then eventually the idea of natural law fades away. There are many different criticism. Criticism in the essentially is that there is no natural law. It's basically subjective opinion of everyone who says that I found the source of natural law. So that's the criticism. So essentially this school gradually starts fading away and legal positivism takes over. But then World War II happens, okay, and then you see so much of killing of people from a certain racial background, okay. And when these people who when then these Nazis were ultimately defeated, they were to be tried, but they were to be tried under what law? There was no positive law that prohibited them from doing what they did, okay. So in order to try and punish them, you needed certain higher laws, okay. So that revived the natural law, okay. So this particular happening development revived the idea of natural law. Now in modern times, to what extent natural law has been successful is something that you can look into, okay. So anyway, in modern times, we study John Finnis, John Rawls as proponents of certain kind of natural law that we will discuss in greater detail later on. So this is essentially what we deal with, okay. Now, to conclude, okay, I will not take it any further. Okay, there are other schools that have different approaches. We will deal with them in different ways. Now, the thing is that you may ask whether all these things concern you or not. Whether all these things concern you or not. It definitely concerns you. Okay. So, for example, your constitution, protects your right to life. Okay. Now the question is, if there was no Article 21 protecting your right to life, will you still have right to life? Can you answer with yes or no? I'm asking you guys a question. Okay. Okay, my question, I'll repeat once again, is that you have Article 21 of the Constitution guaranteeing you right to life and personal liberty. Okay, so focusing on the aspect of right to life. Okay, do you have right to life because Article 21 says so, or will you have right to life even if there were no Article 21, or for that matter, if there were no Constitution, will you still have right to life? Yes or no? Okay, I received both kinds of answers. Some say that you will not have right to life. Now, my next question, if you answered it in the right way, will it be justifiable? So, in the absence of Article 21, okay, in the absence of Article 21, or for that matter, in the absence of any constitution for that matter, will it be justifiable, okay? Or will the question of justifiability even arise, okay? I will simplify. Will the question of, will it be justifiable for someone to take your life, someone to kill you? Now, how will you answer? Those who said you will not have right to life if there was no constitution, I'm just taking one example so that it is understandable to you, okay? If murder was not prohibited under IPC, and if the constitution didn't guarantee right to life to you, okay, will it be justified? Will it be okay for me to kill you? Can you answer yes or no? Am I audible? Are you guys following me? Okay, so I see no, sir, no, sir. No, someone's saying that yes, sir. So I don't know what kind of world you'll be living in if it was okay for people to kill others. Okay, if there were no constitution, I fear you then. Anyway, most of you agree that it will still not be okay for one human being to kill another human being. Okay, now the thing is, those who anyway, so for example, one important case that you might have come across, okay? How many no's do I have? I have quite a few. What do you mean by legally justified but morally no? No. How is that legally justified? Law doesn't say that you have to take someone's life. It doesn't say so. So there is no question of legal justifiability there. If someone was killed without any right, won't that be against the idea of morality? So yeah, that's what I'm saying, okay, that there are certain, where does these questions of morality, moral rules come from, okay? Do they exist or do they not exist? So those who said that it's okay to kill, they say that such rules do not exist, okay? They're saying that such rules do not exist, okay? But then others say that no, it will still not be justifiable to kill someone even in the absence of these rules, okay? So what happens then? So you are saying that there are certain rules which have to be followed, okay? Now a third situation arises in which law says that you kill someone, okay? For example, kill everyone who wears specs, okay? Who's wearing glasses, okay? Kill everyone. So then another problem arises. Then comes the question of legal justifiability, as Adarsh Agarwal was saying, that, okay, so maybe this is legally justifiable, but not morally, okay? But then there are others who would say that this is not even legally justifiable, okay? So, because an unjust law is not law at all. Aren't those examples of such killings even in a state of, sorry, state sanction, but there would definitely be social sanctions. Yes, there could be social sanctions. Yes, definitely. That is the case. We've had these fake encounters. Yes, definitely. But then fake encounters are a case where law is being broken by those who are meant to protect it. Okay, so yes, they're already breaking the law. But I'm also raising a case in which, law mandates that you kill people of certain color, or kill people from certain, racial background, or kill people who belong to a particular, religious group. Will that be justifiable? So these are the things that actually happen in reality. Okay, every other day it happens here and there. Okay, so when, for example, a person is lynched on the suspicion of carrying, some kind of meat or something, we can say that these are the cases in which, apart from the law which is being broken, certain other things are also being broken. Okay, so certain other moral laws which are being broken, and there could be situation where even as legally sanctioned, killing might be considered as unjust. Okay, so these are the things which concern you and I on a day-to-day basis, and we deal with all them. Okay, and this is just one of those many questions. Okay, there are many other things. Okay, so for example, what kind of property, I'm just not restricting myself to this subject, this semester, but also the next semester. Okay, so what are rights, for example? Okay, what are rights? What rights do I have? Okay, so for example, when I say that I have a right to life, does that mean that, does that mean that others merely do not, or the state merely does not have the, power to take away my life? Or does it also mean that state has to do something positive in that sense? In the sense that, so for example, I will die without food. So maybe some minimum amount of food required for survival has to be given by the state. So does the idea of right also mean that? Does the idea of right also mean that I'm entitled to certain minimum healthcare benefits? Does the idea of right mean that I'm entitled to certain basic minimum education? All these questions are things that you deal with on a day-to-day basis, okay? Any case that you take up will always have something which is of jurisprudentially important nature. So whether you like it or not, as a lawyer, you have to philosophize. As a judge, you have to philosophize. So that's where the importance of this subject of jurisprudence lies. So I guess I have to end it here for now, because I've already completed 45 minutes. So tomorrow I'll distribute the topics, project topics. So you guys come up with your own ideas if you have any. We'll do the distribution of project topics tomorrow. It might take a couple of days, but we'll complete it. So thank you for being there. If there are any other questions, kindly drop them here. I'll respond.